there's the mandate for you to investigate somebody dead in a police cell.
Yes, Your Honor.
Read, show the court. Because you have confirmed the scene of death is at the police cell. Which mandate gives you that power? Let him answer.
Your Honor, we are still objecting. Counsel is still taking the same route.
He came under the act. You know, section in this miscellaneous application, paragraph 3, they must have said under which mandate they are coming before this court.
No, don't give him answers. Don't give him answers.
And these are witnesses.
These are witness now.
It's not an advocate. Let him come in front of you. Let him not be given answers.
No. Your Honor, we plead with our colleagues to just remain respectful. We know that they are very good people. Let us maintain the decorum. What we are asking is, as the court has suggested, put the law to the witness. Don't ask the witness to follow the law.
Very well.
We do not mind if you read the law to him and ask questions.
Read paragraph 3 of your. Yeah.
Listen for me, but I can answer.
No, you read it. I just write it. Paragraph 3.
That the investigations by IPOA are pursuant to section 6A, 7.1, and 25.1 of the IPOA.
Is that the law?
Yes.
Is that a fact or that is the law?
That is a fact as per this.
That's what I'm saying.
Yes.
You have quoted the law. True.
Yes.
Therefore, it is not wrong to ask you a question of law because it is yours in your affidavit talk to them. Give me the law that gives you mandate to investigate a person who dies in a police cell. What is it?
I have indicated the sections 6.1, 7.1.
Tell the court. Just tell the court.
Your Honor, I have indicated section 6A, 7.1, and 25.1 of the IPOA.
Could you kindly read to the court those sections that gives you that? The part, just read to the court those sections. The benefit of the whole world. Don't work for it.
Your Honor, because we did not anticipate that a witness of fact will be made to read the law, we didn't carry a copy of the IPOA Act. If they insist that they want to read it, let them just give us the
This day and age of technology, selective amnesia, when he is cornered. It is there. On any phone. Just read. Read the section. 6, you read.
Section 6, Your Honor talks about functions of the authority. Here means IPOA. The functions of the authority shall be 6A, investigate any complaints related to disciplinary or criminal offenses committed by any member of the service, whether on its own motion or on receipt of a complaint, and make recommendations to the relevant authorities, including the violation of constitution, compensation, entire disciplinary action, or any other appropriate relief, and shall make public the response received to these recommendations. Shall I continue?
Yeah, anywhere where the death of a person is specific. My question is specific.
Your Honor, this
JV allowed the witness to read.
Sorry, Your Honor.
Before you even say that, this is a question that has been put to this witness. It is about what he has said. He's being asked to justify why he is here and what gives him the powers. The state, who has not been asked a question, can now stand and start giving him answers or start supporting him. Let him answer.
Yes. Yes, Your Honor, I just wanted to indicate. Section 6 has been referred to in the affidavit. The witness has been asked to read. He has read the affidavit. The witness is being asked about the law supporting an action which is not in the affidavit. That's where the difference is. The witness is saying that Section 6 allows us to do A, B, C. But counsel is asking, does the law allow you to do A, X, which is not in the affidavit? We believe that by him having cited to us the paragraphs he would ask questions on, asking the witness about the law allowing you to investigate deaths in cell, which we have not referred to in the affidavit, is going outside the affidavit, but we would be guided.
So if it's a bed of contention, so let him answer if it falls under the ambit of that section 6. Let him just say.
That's right. That's right.
That provision to the law. And let's leave it at that.
That's right. Yes, that's right.
And the question we are here about is specific to death inside a police cell. And that is all I'm saying. If he says that section, then the court will go and make a ruling out of it. That's all we ask. In relation to death in a police cell.
In police custody.
It's not you to set my question. I've asked you my question. You can't set a question and answer to yourself.
Yes.
If it's not there, it's not there.
The question is, do you have the powers to investigate?
We have powers to investigate death that occurs under police custody.
And that's enough.
Yes, and custody.
That's what I'm saying. The court has gotten what we have asked. The question has been answered. We'll do submissions on it. That's all. Let's go to paragraph. Paragraph 7. You have paragraph 7?
Yes.
Read to the court what that paragraph says.
Your Honor, the paragraph says that the respondent was arrested on 13th June 2025 by DCI officers and subsequently handed over to IPOA and was later put at the Lagat police station by OP 50 13 6 25 at 18:05 hours.
The DCI officers arrested him at what time, according to you? You read exactly. That's what I'm asking.
Yes.
It is not indicated when the DCI officers arrested.
Yes.
Where did they arrest him?
And the DCI headquarters.
And the nota Eldoret confirmed that the accused was not arrested at Eldoret. The respondent.
According to the officers who handed over me, Mr. Salam, the officers informed me that they arrested him at DCI headquarters.
Thank you. I'm putting to you that IPOA released false information to the public that he was arrested in Eldoret en route to escape to Uganda.
That is what my
I'm saying what is in social media is that the respondent
Your
was
Honor, I
arrested.
can only answer what is in this affidavit.
Sorry.
That's not the aggressive position.
Yes.
Let's proceed on the question of arrest. Are you aware the Director of Criminal Investigation, my friend Mr. Mohammed Amin, said the respondent is a person of interest?
That is not in the evidence.
That's why I said, are you aware? If you're not aware, you're not aware.
Counsel, please ask me what is in this affidavit. I'm not going, Your Honor, I'm not going to answer anything outside the affidavit.
I put it to you that based on the DCI mentioning the respondent, on that day at 2 p.m., he presented himself to the DCI headquarters in the presence of his advocate, Juan Keto. Are you aware of that?
You say so?
Thank you. Put it to you. And the DCI authorized these officers together with the advocate to present the respondent to a quiet headquarters.
Your Honor, you have said time and again.
I'm putting it to you.
Please,
You don't need to answer.
Please answer me ask me what is in my affidavit. Let's not change it.
Counsel, I've only put it to you, I've not asked any question.
Is it in my affidavit?
I'm
The
putting
question I'm
it to
asking to you is it in my affidavit?
For the
Answer is
benefit
no.
of the court, I'm putting it to you, then I'll ask you where you are saying you've arrested.
Your Honor, I will decline to answer anything which is not in my
I've not asked. I've not asked.
Then please ask.
I put it to you that the officers handed over the the respondent to IPOA in the presence of Mr. Keto. I put it for the record purposes.
Lagat, Samson Talam was brought to IPOA head office by DCI officers.
And he did record a statement at IPOA in the presence of his advocate, Juan Kiprono. Who is he? I'm putting it to you, Council. You are a council. When it's a question, I'll ask you a question. I'm only putting it for knowledge purposes. So now, if those are the facts, look at the paragraph you said was arrested. Paragraph 7. I'll ask you questions from there. Read.
I have read and read. What is the question, please?
The state is rich, it can bring water for both of us and the council. It's around there. Can you confirm that paragraph 7 is not true, that he was arrested by DCI officers?
The respondent was arrested by DCI officers after he presented himself and brought to IPOA.
Do you have any evidence material to that effect? I've given you the scenario the way it was.
The fact that he was brought under the escort of the DCI officers means he was arrested and brought to IPOA
The
office.
court has taken that. Let's go further.
Sorry, Your Honor, I think this may be my last objection. We hope that counsel is not proposing to court that he has an alternative set of facts which the court should take note of. Because counsel is not a witness. If he wants to give us his alternative facts, we would expect an affidavit so that we also put him on a dock and cross-examine him. Until then, the only factual matter we have is the one given by the witness before.
The only way to prove our falsehoods is by bringing facts that are true. The affidavit is full of falsehoods. We are putting exactly the scenario, and your witness has not recounted any.
Sorry. Your Honor, I am a believer on the law and procedure. What I understand by the law of affidavits is that a person cannot give us factual matters, especially a lawyer or an advocate from the bar. Right now, we have affidavit evidence given by this officer. We are having an alternative set of facts, which may be true. We have no reason to doubt it. But until we have an affidavit, all that is telling us is I put it to you. And we hope it does not go to evidence.
Just to allay you,
Yes.
the evidence that I'm documenting is from him.
That's right. Thank you very much.
Not from Mr. Johnson.
Thank you.
Because as you put it right, it's not giving evidence.
All right.
He knows the procedure.
Thank
That's
you.
why
He's a teacher of the law.
Yes, thank you.
And that's why I told you, wait now is mature to be a judge. Thank you very much. Let's proceed, Your Honor. Paragraph 9.
Regard, first of all, the integrity of the investigations. And they will be provided at the most relevant time. I'm well aware that this will not be the forum where those charges will be filed. Yes.
And I've asked a simple question.
Yes.
Among the annexures, have you produced an annexure showing he was in command of the police station at the time the offense was committed?
I recorded his statement and he confirmed that at the time of the incident, he was the officer commanding the station at Central Police Station. In the presence of his lawyer. I have not attached in this evidence.
Simply answer is clear, you have not attached. All that's what you are looking at. It's not attached.
And maybe to answer your question, any other attachment you may ask is not there, save for the OB extract,
Just don't move. And you are a lawyer. When I say I put it to you, don't respond. I've not asked any question. And I put it. I know. We have our own legal. Allow us to foresee what is relevant, what is not relevant. I put it to you that the OCS left the police station and the deputy was in command as an OCS.
That is not in my affidavit.
I put it to you that the OCS was never near Central Police Station.
That is not in my affidavit.
The world has happened. Let's go. Paragraph 15. On the question of him liking to plan. You there?
Yes.
We have agreed there is no any material.
Yes, not attached.
Let's proceed. Paragraph 10.
Deliver.
Oh, I asked you paragraph 15. I'm going to paragraph 16. Sorry. Still no material attack. Say that very serious material you have kept, no material attack.
Yes, sir.
Thank you. Paragraph 17 about the CCTV.
No material attached, Your Honor.
Thank you. Paragraph 18.
No material attached.
No material attached. Paragraph 17. I've gone back. Because this question of you have said about the CCTV cameras. Do you have possession of the scene of crime as of now? Who is in possession of the scene of crime?
The scene of crime was processed and released. Remember, that's a police station. You cannot hold a station as a crime scene for a very long time. So we have released to the relevant authorities.
Start on off. Because I was there yesterday. It's not true that the scene of crime has been released to the police. Is it still a scene of crime or it is non-operational police station?
That question is not exactly that.
You brand it. Do not lie like that. So you cannot, there's no material to show that.
Nothing such.
Paragraph 19. Read it?
Yes, sir.
And 21, they are the same.
No material attached.
There is no material. That's very, very important for us. Paragraph 22. I still ask you this question about the blue code of silence.
I will refer you to the High Court decision.
Tell the court. Which this is a lawyer, he knows the court decision.
Court of appeal decision.
Give the court.
The titles in above case 2020. First one, point by the guy who's been. Yeah.
And I remind you, Cliff is the one who had the partner. He's here. He'll face you over that one. He's the one who had the partner. Cliff will deal with the money.